everything, yeah. My everything is you, Lord. Yeah. Ha-ha. Oh, 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 oh. Everybody say, ah. Say, how can I express my gratitude for all the many things you've done for me? Words are not enough, yeah. Enough to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things? All the many things you've done, Father, you done for me, yeah. Words are not enough to say thank you. Say, Lord, you are. Lord, you are. You're my everything. Say, I call you Jireh. You're my provider. I call you Eunice. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. Lord, you're my everything. I call you Jireh. Lord, my provider. I call you Eunice. You are my battle. I call you Rapha. You are my healer. Say, Lord, you are. Lord, you are. You're my everything. Boy, I'm a thing in now. Boy, I'm a thing in now. Boy, I'm a thing in now. Oh, boy, I'm a thing in now. Yeah, so boy, yeah. Boy, I'm a thing in now. Boy, I'm a thing in now. Yeah. Boy, I'm a thing in now. Oh, boy, I'm a thing in now. Say, I call you Jireh, say. I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are my everything. Yeah. Are you ready, everybody? All right, listen. William Miguel, come here. 1, 2, set. It's the last Saturday of the month of July 2025. Ladies and gentlemen, my brothers and sisters, friends and clients alike, can you remain in the property you and your partner bought together after you have separated? I know it's a big question you want an answer to, so I'm inviting you to join us on the program The Community and the Law, brought to you by BWF Solicitors. My name is Ulrich Frimpong. Welcome to the show. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340 or our emergency line is 07712 761 884.
I will start with a thank you because you have decided to join me on this program, The Community of the Law, this very last Saturday of the month of July 2025. And we're going to do that together. The community is in need of information. The community needs knowledge. The community needs education. The community needs empowerment, especially when it comes to the law. And we are doing this to help you achieve all those targets that I mentioned earlier on. And we're doing this with the help of BWF Solicitors. My name is Oreku Frimpon, and a very hearty good afternoon to you for joining us this afternoon again for the community and the program, the community and the law program, so to speak. We're going to have a 2-hour journey that will be full of information, full of empowerment, and also the opportunity for you to ask your questions about so many things, especially when it comes to the law and immigration matters. I've told you that we're doing this courtesy BWF Solicitors are trusted partners when it comes to the law. BWF Solicitors is on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, in North London. Call them on 0208 493 7340 or our emergency line is 07712 761 884. 7340. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. What do they do? We ask them to help us to put in all the various applications when it comes to our immigration matters here in the UK. We want to understand the law, the changes that have come, and any updates that are being given us. We really want to understand and know how to work with them. BWF Solicitors does that. When it comes to marriage and divorce here in the UK, and especially when you have gone through those two situations, what do you do when it comes to your immigration matters? And then again, if decisions have not gone your way and you want to appeal, how do you go to court? How do you prepare yourself for all that? What are the strategies that you need? BWF solicitors are masters in the game. So I would recommend that you visit them, speak to them, contact them, and get them to do all that for you. 0208 493 7340. They have an office in Ghana, and those of you in Ghana, you can call them on 055 589 5959. 055 589 5959. Or in emergency situations, you can call, text, or send a WhatsApp to this number 077 127 61884. And you can also contact BWF Solicitors, visit them on all their social media platforms, Facebook, YouTube, X, and all the other ones that are available to you. Once again, welcome to the show. I know people who have joined us have announced themselves. We're live on Facebook at BWF Solicitors and at BWTV UK. We're also live on YouTube at BWF Solicitors and BWTV UK. When you join us, I have said that you announce yourself, let us know, like the page, invite people to come and join us. And if you are new here, subscribe to the channel so that whatever we put out, you will be notified. So if you're here, welcome. And I believe people are there. I would want to believe that, yes, people are around. Watching live from West London, Kojo Tufuo has announced himself. Thank you, Kojo. Kojo T, I'll call you. Tilly Duma is here and says, please kindly share, comment, and like. Thank you, Tilly. And she also saying thank you to everybody. Hello, lovely family. Tilly, hello to you as well. We move on to the next one. Nanajima, Senior Minister, Bradna, class is going on. Virtually saying that, yes, come join us. The class is on. Ade Taribu says, please share when you join. Thank you very much, Ade Taribu. You one of the very regular persons who join us whenever we have an episode, The Community of the Law. And it comes to your way every Saturday between 4 p.m. and 6 p.m. UK time. Now, this afternoon, what are we looking at? We are going to pose a question, and I believe it is one of the things that's bothering so many people. The question is, can I remain in the property my partner and I bought together after we have separated? Now, when you join somebody in a relationship, you would want to really go on forever, happily ever after, as we normally. But sometimes they do not work. They do not really go on the length of time that we want it to last. So what happens? Now, when the relationship is formed, you do things together. You buy property together, you have children, you go into investments and all that. Now, one thing that really bothers people is the fact that Kweku and the partner have bought a property, a house they live in together, sometimes with their children, sometimes them alone, or with other people. Now, when the relationship doesn't work and they have every reason to go their separate ways, what happens to the house they have bought together? Can I remain in there and live there for as long as I want? Or something happens? What does the law say? We're going to have a look into this. And I'm privileged and honored to have lawyer Eunice from BWF Solicitors, who's going to be a resource person and guest this afternoon. And with your permission, brothers and sisters, ladies and gentlemen, let me welcome on board lawyer Eunice Achampong. Auntie Eunice, good afternoon.
Good afternoon, Kweku. Looking lovely as always. I like your shirt.
Thank you very much. The sun is out, so I'm trying to kind of represent properly. So thank you for acknowledging that. I'm proud. You can see my cheeks going. All that. Thank you very much. And you're looking good as well. How's everybody?
Oh, thank you. Thank you so much. And thank you to our viewers who have joined us for today. I know that usually with our weekends, we have our faithfuls and we have those that will share to others who are not necessarily on this YouTube channel or on Facebook. So thank you so much for joining us for today's program. I hope your weekend is going well and I hope you're all doing well by God's grace.
Yes, and you're doing well, to be fair. I can represent everybody here. And we are also very grateful for what you do for us as a firm. And we are not being ungrateful, so we express it every now and then. And I have one that I've chosen to put to you and even show to other people that we appreciate what you do for us. Now, David is the person I'm talking about, Lawyer Eunice. And David says that I'm very happy with the excellent work done by BWF Solicitors in helping my three children get their visas to the UK. Nice working with experienced solicitors like Boss Bernard and Chelsea. David is quite happy. And as I said, we're grateful and we don't want to show that we're not grateful. We are very grateful. And we want to let you know that we are. So that's David, at least one of the very many people who have shown their gratitude, like Eunice.
Yes, we are truly grateful, David, because children applications usually, when you ask anybody, the requirement, especially to do with sole responsibility, is quite a high threshold. It's not very easy to overcome unless you have the right information and the right documentation to prove that you have sole responsibility. And so, for him to have been granted, and his three children to have been granted leave to enter the UK. It's not really an easy feat. And obviously, congratulations to Chelsea as well. She's one of our staff in Ghana. And usually, when I say Ghana, people assume that we deal with Ghanaian law, but we deal with UK law in Ghana. And
Hmm.
so Chelsea is well versed with the UK law, and she was able to put the client in the right direction so that he could provide all of the documentations that were needed to have his three children come with him to the UK or to go and have his children um, come to him in the UK. And so usually, I know many people who come with refusals based on the child not being granted. And so it's not one of those easy applications that you could just sit at home and just easily do. They are quite cumbersome, and then the threshold, especially to do with sole responsibility, is quite high. So, all congratulations go to Chelsea and then, of course, Mr. Wusu as well.
Right. Well, thank you very much, David, for expressing your gratitude. And I know so many other people who are in your situation would express same as well. But then also we would want to continue to improve on the service we provide you. So if you have any feedback, don't hesitate to give that to us. You can reach us via email admin at bwfsolicitors.com, or you can call us and let us know 0208 Those in Ghana, and as our brother David has experienced, the Ghana office is as efficient as we are here in the UK. So you call on 055 589 5959. In emergency situations, just reach us on 077 127 61884. Our website, bwfsolicitors.com, or our social media platforms. You can find that on your screen. So thank you, thank you, thank you, thank you. Now, this week, something uh, took effect, and I want you to really note what has changed today for care visas and certificate of sponsorship. The new immigration law has changed the nature of care visas and the route. Healthcare sponsors can only sponsor or issue new certificate of sponsorship, that is COS, to only two categories of people. I want you to really note that, and I know Eunice would further expand that for me. Healthcare sponsors can only sponsor or issue new certificate of sponsorship to only two categories of people. One, those already in the UK with care visas, those who have worked with prospective sponsor for at least 3 months before the 22nd of July 2025. So if you are in either of the categories I've mentioned, yes, the sponsor can sponsor you. Other than that, I don't think it's possible. Those already in the UK with care visas, and those who have worked with the sponsor or the prospective sponsor, so to speak, for at least 3 months before 22nd of July 2025. So the warning here is be careful of scammers out there. Don't be scammed. Take proper advice and do the right thing. Laura Eunice, I guess I'm right.
Yes, you are. I mean, when it comes to our sponsorship applications, I think this is like a continuation from what we discussed last week. And when it comes to our sponsorship applications, a lot of people are within the health and care sector. And so it makes sense for us to advise people and then also to let people who are within this category know that as much as possible, these are the things that they need to do or they need to look out for in order to obviously stay on the right track. So when it comes to what we were talking about last week, for instance, we looked at the new statement of changes that came out on the 1st of July 2025, and the fact that the government have said that there are changes in terms of those who are already on the health and care visa. So we know that on the 22nd of July, anybody who was applying to the health and care visa route from outside the UK would no longer be able to do so because the government has put a stop to it. And so there will be no entry clearance applications whatsoever from now on for those who want to work within the health and care sector. And then also, if you look at our poster for this week, our update, it talks about the fact that you cannot obviously go on to have a care worker who is already in the system. Let's say the person has, for instance, switched to a different route and wants to come back to the care route. They can't obviously do so unless they were already working for the employer at least 3 months before their COS was issued. And that is clearly stated within SW6.1A of our immigration rules, that you should be able to show that within um, the immigration rules, you've worked for your employer within the COOS occupation code of 6145 and 6146 for at least a period of 3 months in order to renew your certificate of sponsorship. And then you also have those who are already in the system. And I know there are those people who are, for instance, um, people who've put their names into the pool of employees who are still looking for sponsors to offer them jobs. And if you were granted a COS before the 22nd of July 2025, of course, you can go ahead and make that application for your leave to remain to be extended. So you have people who are already here in the UK who are probably within a pool of employers list to be able to extend their leave in the UK. With those category of people, if they have an employer who has already issued a COS before the 22nd of July 2025, they can go ahead and then obviously say that they are extending their leave on that basis. Then you also have those who are, let's say, under the occupation code 6146 or 6145, who are also saying that because of the fact that have worked with the employer for at least 3 months, they are also making an extension on their leave to remain in the UK, based on the occupation codes that were given earlier. And so, yes, it's quite a tricky one. And of
Mhm.
course, I will have a lot of people who ask more questions. But if you do have any questions in regards to this specific issue, do not hesitate to contact us for more information.
Yes, and like this is just rightly put it, do not hesitate to contact BWF Solicitors. The number again, 0208 493 7340, or in Ghana, 055 589 5959. In emergency situations, 077 127 61884. Now let's delve into knowledge here. Um, it is possible to regularize your stay in the UK as an overstayer if you have lived in the UK for less than 20 years, but have an extremely difficult health condition or other circumstances that would make your reintegration into your country of origin difficult. This, I believe, includes life threatening physical and mental conditions, suicidal situations, and other threats to life. The application to regularize would be under private life. I believe that we would have some more in depth into that. And when successful, you would be granted 2.5 years to remain under the 10-year path to settlement. Remember, it's always pretty important that you can prove such conditions, such circumstances, or those situations that would make reintegration back into your country impossible. I've mentioned some of those situations: suicidal situations, mental conditions, life threatening physical situations as well. But remember, you have to prove that. Now, this is from paragraph 5.1b of Appendix Private Life to the immigration rule. Eunice,
Yeah.
I know people who have lived here for some time and obviously are not well grounded, would have to spend 20 years before they could be considered. But then this is telling us that we could do that in less than 20 years based on these conditions. Can you help us with it?
Okay, so as you can see from our nugget, it specifically mentions paragraph PL5, which is under Appendix Private Life. So previously, you would have heard us say under paragraph 276 of our immigration rules, but as of 2022, the government decided to simplify our rules and then created a new appendix, which they call Appendix Private Life, and it categorizes all those people who can make applications under the private life route. Um, you can see clearly from our nugget that there are those who may have lived here for less than 20 years who may also be able to make an application under Appendix Private Life. Usually, those people are people who are over the age of 18. They may not have lived here more than half of their life or lived here 7 years of their life, but they are saying that there are obstacles to them returning to their country of origin. And you must be able to show what obstacles will hinder you from returning to your country of origin. And
Mhm.
usually, as we always say, insurmountable obstacles are not very easy thresholds. They are quite high thresholds, and you
Yeah.
should be able to give your reasons as well as evidence to explain what insurmountable obstacles or what great difficulties you will encounter if you were to go to your country of origin. And as the Home Office always do, they have policy to guide them as they make their decisions in regards to applications such as these. So most people would have to show that they've lived there for 20 years to be able to make an application under the private life route.
Mhm.
But if you've lived there less than 20 years and you are not a young adult who's lived there more than half of your life, or you are not a child under 18 who has lived here for at least 7 years continuously, then you will have to show that there will be insurmountable obstacles to you returning to your country of origin. And usually they would give you that leeway to be able to give your reasons. And so, as we can see from our nuggets, reasons such as a threat to your life, the fact that maybe you might have a sickness or an illness which you may not be able to receive the treatment back home, or you may not be able to fund yourself if you were to return back home, or the fact that when it comes to you going back home, there is nothing else for you. And so family life is here in the UK. Every social or cultural tie that you know is here in the UK. When it comes to maybe the fact that you also have property and assets, they are all here in the UK. And when it comes to the length of time that you've lived here, maybe it might not be 20 years, but because you've lived here long enough, you have obviously established very deep roots here in the UK. And so they have to consider it on a case by case basis and holistically. But as I said, insurmountable obstacles are very high thresholds, and usually, when you look at Article 3 of our human rights, it talks about the fact that when it comes to our being, if we are to suffer any sort of detriment that will mean that our lives will be at risk, then obviously we have that freedom from torture and from our lives being at risk, or our lives being harmful to the point of death. And so most of the time, because that is such a high threshold to meet, we have Article 8. Article 8 is our right to private and family life. And usually people would say, yes, if I'm able to prove that my family life is here in the UK, or I'm able to prove that I've built deep um, ties, social ties, cultural ties, emotional ties, then maybe that should be enough for them to have a look at my situation. But you can also express the view that, of course, when it comes to any illness, if you are not going to be able to receive the treatment back home, and you are looking to those who are here, who are your family members, to be able to care for you and to be around you during this period of time, that also can be considered under Article 8 of our ECHR, which is our European Convention of Human Rights. And so it's very, very important to give your reasons as well as evidence to back what insurmountable obstacles will be in place if you were to return to your country of origin.
I have an interesting question. I know you're not a medical person, you're a lawyer, but
Yes.
let me put it this way. If we talk about mental conditions, life threatening mental conditions, what could be an example of that?
So mental conditions is a very broad topic, and I think um, in this day and age, especially in recent years, there has been so much attention given to people's mental health, and so obviously when they talk about mental health, they will include things like depression, extreme anxiety, postnatal depression, people who have psychological issues, and even to the far extent of schizophrenia. So you have like a wide range when it comes
Hmm.
to mental conditions. But obviously, you have to be able to explain why your mental condition is a risk to yourself and to other people, and whether that is life threatening in itself.
Okay, so then in this case, it has to be supported professionally by a physician, maybe.
Yes, definitely a consultant's report into your condition will be the first step to take in terms of showing evidence when it comes to cases like this.
All right. Well, so as we have gotten the explanation and have we told you, it's possible to regularize your stay in the UK As an overstayer, if you have lived in the UK for less than 20 years but have an extremely difficult health condition or other circumstances that would make your reintegration into your country of origin quite difficult. For any further discussion on this, if you want any further detail of that, you can consult BWF Solicitors on 0208 493 7340. BWF Solicitors, 4th floor of the Anna House, 214 to 218, Tottenham High Road, 7 Sisters. Work Monday to Friday, 9:30 in the morning and 6 p.m. Or you can also contact them on the social media platforms that we have, Facebook, YouTube, and all that. Leave comments there, and they will respond to you. You can wait when we come on the program, the community and the law, every Saturday afternoon. You can contact us. We have a text message 07399208468. That's on WhatsApp as well. Or when the lines are active, like we're going to do this afternoon, you can also call 208-493-7345. Now, having had this, let me ask you an interesting question, because I'm going to give you a scenario. Araba and Fifi married under Ghanaian customary marriage law on the 1st of June 2022. On the 30th of December 2024, they registered their marriage under Section 2 of the Ghanaian Customary Marriage and Divorce Registration Law of 1985. They were subsequently issued with a certificate of marriage which indicated the date of marriage and registration. Under Ghanaian customary marriage laws, one can register a marriage at any time in the future after the marriage has been contracted. Araba applied for a visa in May 2025 to join Fifi in the UK. Araba's application was refused in June 2025. The caseworker said that as the marriage was contracted on the 1st of June 2022, it should have been registered on the same date. Therefore, the marriage is not valid according to the caseworker. As a result, Araba cannot be the spouse of Fifi. Araba has appealed against the refusal decision, and my question is, what would be the likely outcome of this appeal? I've given you the scenario. I've taken my time to explain it. So think through it properly. What would be the likely outcome of this appeal? An appeal will be allowed because Araba can prove that both she and Fifi attended their marriage in Ghana. Could also be an appeal will be allowed because Araba can prove that her marriage to Fifi is valid in Ghana. The third one is an appeal will be allowed because Ghana is an independent nation. Think through this. The tail of the program, I'll come back with a scenario, take my time and explain the situation to you, and I would ask you to help give either some hope or despair to our friend Araba, who got married to Fifi under Ghanaian customary marriage on the 1st of June 2022. Well, it's still the community in the law. I want to say thank you to BWF Solicitors, our generous benefactors and our sponsors. And when we come back, I'll be asking you the question. And the question I'm going to ask you is an interesting and a straight one. Can I remain in the property my partner and I bought together after we had separated? Lawyer Eunice is here to help us with that. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. It's still the community on the law, and it's brought to you by BWF Solicitors, our trusted partners when it comes to the law. Can I remain in the very property my partner and I bought together when we were together, and then now we have separated? Can I remain in there? Is there a law that protects me? Can I be sacked from the property for any reason? Lawyer Eunice Achampon is a partner of BWF Solicitors. She's a resource person and guest this afternoon. Lawyer Eunice, as I often do, I would want to pick up the question and drop it straight in front of you. Can I do that?
Yeah. So there are categories of people who would be able to do that, and we'll delve deeper into the topic as we go ahead. So yes, when it comes to couples, especially those who are not married, because when we say partner, partner is a broad term. It could mean a partner who was not married to the other party, or it could mean that they were married, but unfortunately things didn't go as planned and they've had to now break up, and now they're having to look at how things will follow on from the breakup. And so yes, when it comes to relationship breakdowns, whether you were married or you were living together as cohabitees, there is always a way to obviously gain your side of your property if you were able to show clearly that you meet the certain criteria in the law. I know for married people, it's much easier because you don't necessarily have to do much because the law is always on your side. It's different for those who are unmarried, and therefore those category of people are always found wanting when they are looking to see if they can have the property um, obviously sold over to them, or to even have the property divided into beneficial shares, just so that they are able to continue to remain in the property. And it's quite, should I say, difficult for those who are not able to have the law on their side. And so we want to delve deeper into such areas so that we understand where we stand if we are not married, and how we can also put things in place that will help in the future as well. And I know a lot of people have questions. I had somebody who came and was just pouring her heart out, and I said, okay, I think it's good to obviously let our viewers also be aware that this is what they need to put in place, and the don'ts and do nots as well, in terms of buying a property together, whether you are married or unmarried.
Um, a bit of a naive question, but let me still ask you. If people are in a relationship and they are not married, is it really advisable for them to acquire property together, do they have anything in the law that protects such situations?
And so for people who are not married, unfortunately, not as married couples, because you have the Matrimonial Causes Act, you have the Matrimonial and Family Proceedings Act, you also have the Married Women's Act of 1882. So there's a lot of law in place for married couples where if one spouse, for instance, were to leave the relationship, the court will have that objective to make sure that both parties were going away with what was suitable for the family. Whereas with those that were are not married, it makes it quite difficult because the law is not necessarily on their side. And so they would have to show that there was an intention to purchase the property together. And therefore, they have declared their trust in the land when they were buying it. And if they did not declare their trust in the land, and for instance, they bought it as joint tenants, that means that they both put their name on the title deeds, then at least they will start from there. The court will start looking from that point on, because for two people to be named on the title deed, that means that there must have been some financial contribution from both parties to be able to make that contribution to buy that house. Whether it was mortgage free or with a mortgage, there must have been some financial contribution on both sides of the party to be able to purchase that land. And in terms of the law, if you are able to show that you have purchased the property and you have contributed financially to that property, there is the Trust of Land and Trustees Act that you can also look to. And in short, we call it Tolata. So the Tolata of 1996 is what most people who are able to show that they have bought the property in joint names, or that there was a declaration of trust by the two parties that bought the property in joint names in the title deeds. Then, of course, you can rely on Section 14 of Tolata. And I know that our producer will have that for us in his slides. When it comes to the law, at least once you know what the law says, then you become armed with it. So when you look at our heading, it says Trust of Land and Appointment of Trustees Act of 1996. And as we look down at section 14, it talks about the fact that when you are applying for an order, which is usually an order under the trust of land to the court. So usually it is the court that will make an order. It talks about it in subsection 1. It says that any person who is a trustee of a land, so any person who has been named as a joint tenant or has a declaration of trust on the land, or has an interest in the property subject to a trust of land, may make an application to the court for an order under this section. And then it goes on to say in subsection 2, on the application for an order under this section, the court may make such an order relating to the exercise by the trustees of any of their functions, including an order relieving them of any obligation to obtain the consent of, or to consult, or any person in connection with the exercise of any of their functions, or declaring the nature of or extent of a person's interest in the property subject to the trust. So it means that the court has all of these powers. They can make an order either to prevent somebody from going on with the land as they would have normally, and they can make an order to obligate somebody to do what they would not necessarily have done if they were out of the relationship, or they can even declare that because of the nature and extent of the person's interest in the land, they can still hold their trust until further notice. So the court has all of this power under subsection 2.
Mm.
And it's important to know that once you make this application, the the court will have view of everything that is in regards to the property that was bought. So if you bought it as joint tenants with your names on the title deeds and you made contribution, let's say one couple put 10,000 in and the other person put 20,000 into the deposit of the property. Maybe the property has a mortgage and therefore you've put in the deposit and maybe one party is paying the mortgage or both parties are paying the mortgage. The court will have to have sight of all of this. And then if there are children involved, and most of the time there are always children, depending on the fact that when it comes to relationships in general, nobody thinks about a relationship ending. You always go in with the mind that this is forever until something happens and then the relationship breaks down. And so this is the law that most unmarried couples may be able to rely on when it comes to
So Laura,
the
my
property.
question here is, when two people are going into that, they are in a partnership relationship, or married partners, and then they have children. At a point in time, they decide to go their separate ways. What will be the fate of the children in this situation? Are we going to look at the trusteeship, if there's any word like that, of the adults and the parents, or are we going to consider the interest of the children in determining who should take what portion of the property when there's separation?
Okay, so when it comes to children, and especially because children are seen to be of great importance, and so the court always says that they must put children as paramount, and
Mhm,
so the interest of the child is more important than the parents or the two adults that are fighting. And
mhm,
so with the court, anytime a case like this is before the court, they look at what the parties have applied for, and then if there are children obviously involved, then it is part of the objective of the court to make sure that their children's interests are put as paramount. And so what that means is that if, for instance, a father has applied to the court for his beneficial share or interest in the land because his name was put there as a trustee, and he believes that he should have his fair share, and he doesn't really care if the other party is not able to get much in any case because they only put in a deposit, they didn't pay towards the mortgage, they didn't do much financially. Obviously the court is going to be looking at who is caring for the children now. Is the parent who has applied for the order working? If the other parent is not working, who obviously um is caring for the children in terms of their education, in terms of their well-being? Usually once they consider all those things in regards to the children, and if it's one of the parties who is mostly at home caring for the children, taking care of their needs physically, emotionally, psychologically,
mhm.
including their educational needs as well, then it would seem likely that the children will have to remain with that parent. And if it's that parent who has to leave the house, then the court might make an order to restrict the purchase of the home until the children are old enough. And most of the time, when the court considers the children's interest, it has to make sure that the children are sorted in terms of all of this before any of the parties can get what they want. So if, for instance, one party wanted the house to be sold so that they can get their share, and the other party is saying, well, I don't have the financial means to look for a property or buy a property at this moment, then the court has to consider the fact that that party is unable to look for a place of their own, and that the child obviously needs to be well catered for, especially when it comes to matrimonial cases where the couple are married. The court can obviously make an order as to the fact that when the children are 18, then they can go ahead and obviously sell the land. If it is the case that they are unmarried, the court still has leeway in terms of Section 14, in order to make sure that if the other party wants their beneficial share, maybe they might be able to take out some equity, whereas the other party may have to work to pay the mortgage in regards to remaining in the house. And so the court will always look to putting the children first or making their interest paramount than what the other parties may want.
Well, there's this interesting thing that just crossed my mind. Now, in fact, two things. Let me ask the first one this way: who determines the interest of the children? Will the children have a say when it goes to court? And the judge would listen to a child who is younger than 16 years and say, Kofi and Amma have Ekwemenu as their child. Ekwemenu thinks that I can live with Kofi as my dad, not Ekwemenu. Would the judge listen to the young person's view in determining the interest of that child?
Okay, so usually when it comes to children, um, most of the time it is the court that has that obligation to consider their best interest. And so unfortunately, when parents are in this, unfortunately, I don't think most parents are thinking of the children and what their future is going to be like in this situation. So the court will have that obligation to consider the children's interest, because situations like this are never nice. They are never situations that I would say somebody is looking forward to. Nobody wants to be in this situation, and nobody wants to obviously have their children dragged into it as well. So when it comes to the obligation of the court, they take it very seriously to consider their children's interest first. And most of the time, most children may not even know what they want at the age that they are at, unless you are talking about like a 13-year-old child who has expressly written a statement to the court that they prefer to live with their mother instead of their father, or their father instead of their mother. And so in cases like that where the child has expressly written a statement to tell the court that they also would prefer to live with their other parent, the court may look into that as well. This happens a lot when it comes to child arrangement orders, where you want to make an you want to make sure that you have direct access with the child, and usually the court will consider the interest of an older child rather than a younger child, because sometimes a child may not necessarily know what they want until they are old enough to understand what is going on. Yes.
Now, in some peculiar situations, these two adults who do not see eye to eye with each other would say that, well, for the purpose and the interest of the children, we will cohabit, not as partners, but at least we live for the children to have that kind of protection. Would the court allow them to live together with the children in such an arrangement so that the children will have their interests catered for, their safety, their security, and everything?
That's a very good question. And I think that most times before you even come to the court is looking to see if you've tried mediation. Have you tried talking things out? Have you tried to come to an agreement as to how you want to end your relationship. And most times it is when the two parties are not able to agree that it's escalated to the courts. And those parties that are able to try family mediation and are able to draw up an informal agreement, which is binding to the two of them,
Mm-hmm.
that's the best way to go, because at the end of the day it means that both parties have the children's interest at heart, and they are making sure that because the children come first, they wouldn't want to disrupt the family life just because they are not getting on as a couple. They want to make sure that the children receive the best of them, and therefore they have made that decision to live together, or should I say, live separately within the same household, and then make sure that the children are getting the best that they can from them. And so, if a couple is able to do this even before escalating it to the court, that is even better, because the court is always looking for those couples that are willing to try mediation before obviously coming to the court. And if at some point within court proceedings you come to your senses and you think, oh, do you know what? I don't want to go ahead with the court proceedings. We want to actually live together. Then, yes, both sides can have their solicitors draw up a formal agreement, which the court can obviously rubber stamp, or should I say, sign and seal, so that both parties are aware that they will go ahead with the agreement that they themselves have put together, and then leave everything until such time when they have changed their minds. It's always a good thing.
So the question obviously we're asking is, can I remain in the property my partner and I have bought together when we have separated? The legal basis of the interest both of you have in the property has been outlined. When the inevitable happens and you would have to go your separate ways, how do you um, split the property and who has interest and all that? And when there are children in there whose interests are greatly considered, obviously we're talking about the children's interest being paramount and the rest of it. If you have just joined us, that's what we've been discussing. If you have a question, you can put that in the comment section down below, either on Facebook at BWF Solicitors or at BWTV UK. Also on YouTube at BWF Solicitors and at BWTV UK. Remember, we're doing this courtesy. BWF Solicitors are trusted partners when it comes to the law. And we have a partner and a lawyer from BWF Solicitors, lawyer Eunice here to help us discuss this very pertinent question. I know you would want to stay and ask your questions. So get ready, because after this break, I'll ask just a few questions. Then I'll go to your questions and your concerns. But before then, remember I told you about two people who got married in Ghana, and there's a situation they are faced with. Araba and Fifi's situation is what I'm talking about. They married under Ghanaian customary marriage law on the 1st of June 2022. And on the 30th of December 2024, they registered their marriage under Section 2 of the Ghanaian Customary Marriage and Divorce Registration Law of 1985. They were subsequently issued with a certificate of marriage which indicated the date of marriage and registration. Under Ghanaian customary marriage laws, one can register a marriage at any time in the future after the marriage has been contracted. Now, beyond that, Araba applied for a visa in May 2025 to join Fifi in the UK. Araba's application, unfortunately, was refused in June 2025. The caseworker said that as the marriage was contracted on the 1st of June in 2022, way back, I think 3 years down the line, it should have been registered on the same date. Therefore, the marriage, according to the caseworker, was not valid. As a result, they said that Araba cannot be the spouse of Fifi. Araba has appealed against the refusal decision. So I'm asking what will be the likely outcome of this appeal. Three situations I've given you. An appeal will be allowed because Araba can prove that both she and Fifi attended their marriage in Ghana. Uh, an appeal will be allowed because Araba can prove that her marriage to Fifi is valid in Ghana. And then the third one is an appeal will be allowed because Ghana is an independent nation. Which one of them would be the most likely outcome of this appeal? Think through it and let's help Araba either give him hope or despair. But I hope we give her hope because we are with BWF Solicitors who always give us hope. We'll take a break, and when we come back, we'll come back to our discussion.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. You're live with us on BWTV, and we come your way courtesy BWF Solicitors on the program The Community and the Law. The question I have asked this afternoon is, can I remain in the property my partner and I bought together after we have separated? Lawyer Eunice and Champon is here, sorry, and she is helping us go through this. So many people are faced with this situation, and I believe our discussion this afternoon is really helping you. I may not have all the questions, so if you do have any question to ask concerning this topic, send us a text or a WhatsApp message 07399 208 468, 07399 208 468, or I would activate the telephone lines very soon, and that would be 0208 493 7345, 0208 493 7345. Or there, you can leave that in the comment section down below. Eunice is here, and let's get back to the discussion. Eunice, when there's separation and people want to go their separate ways, do we have to split the property probably according to the proportion of what we contributed at the point where we were acquiring the property? Or one person probably, when there's children, who has more responsibility towards the children, will have a greater portion of that. Maybe as an extension, would have the backing of the court probably to determine what happens to the property.
Usually in cases like this, if both couples can agree, like I said beforehand, it's even better. But if they are not able to agree, usually it is the court that will usually look at whether a transfer can be made to one party, and if the party is financially capable, for instance, if there's a mortgage on the property, whether they are financially capable of keeping up with payments on the property, and if the other party were to leave the home, obviously would they also be capable of renting a property on their own as well. And so, in cases where, for instance, the couple are not married, um, there has to be a notice of severance that is, should I say, um, given to the other party so that they know that the other party is now looking to have their beneficial interest in the property being given to them rather than just leaving the property to the party who is living within it. And so, if our producer can help us with the slide in terms of looking at the Law of Property Act, where, for instance, the couple haven't been able to agree, and so the court is now having to take on that, should I say, obligation to now decide which party or how the property can be divided between the parties. So if you look at Section 6 of the Law of Property Act, it's a very old act, but it's still being used today. It says joint tenancy. So where a legal estate not being settled land is beneficially limited to or held in trust for any persons as joint tenants, the same shall be held in trust in like manner as if the persons beneficially entitled were tenants in common, but not so as to sever their joint tenancy in equity. So what that is basically saying is that if the parties were to hold the property as joint tenants, so they both have their names on the property and they both have their beneficial interest. So for instance, both parties have declared their trust in the land. So when they were buying the property, they put their names on the the title deeds, and then they declared that maybe one party will have 40%, the other party will have 60%. And they made that declaration clear on the title deeds. But if they have gone on to say that they are now breaking up, maybe after 20 years of being in a relationship, then the parties will have some form of um, seeking the court to try and divide their equity within the household. So maybe there were equal or separate deposits that were being made into the mortgages account. And since then, maybe there has been a shift in the financial contributions by one party. So maybe on the title deeds, nothing was declared. They've just put their names there as joint tenants. But as time has gone on, one person has made more financial contributions than what they did during the time of the deposit. So if they are an unmarried couple, most of the time the court will have, uh, should I say, an idea as to what contributions have been made so far within the property. A very landmark case or well known case is the case of Stack and Dowden. The couple were together for over 20 years. They were not married, they had four children. They decided that they wanted to put an end to their relationship. They applied, and the case went all the way up to the Court of Appeal. And they realized that, well, even though the man or the so to speak cohabitee husband had applied to the court to sever the equity he had within the land or the property, they realized that the woman had made more financial contribution towards the property, and therefore it couldn't be shared in equal shares. And so when it came to the fact that the man was saying, well, on the title deeds, we did not express how we would hold the trust. We just put our names there. So in that sense, because it's automatically 50-50, I want 50% of the equity in the land, and the other party should keep the 50%. Well, the court said no. In terms of a resulting trust, she has made more financial contribution. She has paid financially more in terms of the mortgage, because there was a mortgage on the house, even though they made equal shares in the deposit when they were going to buy the house. She had made financially more contributions to the property, and as a result of the fact that she had made more financial contribution to the property, the court decided to split it 65-35, in terms of what each party will get in equity. And that was how the court split their beneficial interest as a party or a couple who were not married. And so it's very important to know that when it comes to obviously the court looking to see how much money has also been contributed towards the property as a form of resulting trust, they will look at this and also consider the financial contributions made by both parties before they obviously make a decision. The man thought he could get away with the fact that his name was on the title deeds and there was no express or declaration of trust. And so it was going to be automatically 50-50. But the court decided otherwise. He tried to appeal to the Supreme Court, and the Supreme Court still agreed with the Court of Appeals decision. So it's very, very important that if you are buying land together as a couple, especially I know that within our Ghanaian community, we are not very much aware of these things. So we decide, okay, let's put it in one party's name. Later on, the children can have it. It is very important that both parties have their names on the title deeds, and then usually the lawyer is supposed to advise both parties to also make a declaration of trust if they are buying the properties as unmarried couples or cohabitees, so that at least they know that later on in the future, when something they didn't plan should happen, then they can rely on the declaration of trust that they made at the very beginning on the title deeds, so that when each of them go their separate ways, they know that this is the beneficial interest they have in the land. If not, the court will now look at it as a resulting trust in terms of the financial contributions that have been made by both parties before each party is able to have their beneficial interest. And like we were saying, in terms of the children, if it's the woman who has made more of a financial contribution to the household and the property, then she is more likely to remain in the property, and then the other party can take their equity out of the property, and then she will have to continue paying the mortgage. And in such cases, obviously, once equity has been removed, the mortgage uh, payments per month may also increase as well. So obviously, it relies on both parties to make an agreement before going to court. And if they can't agree and the court does make an order for one party to remain in the property and they are capable of paying the mortgage, then they can remain in the property and then continue with payments. Otherwise, if they are not able to do so, then that would also mean that both parties will have to leave the property and each take their share and find something else that will be more suitable for the family. And if they are able to do so, they will have to advise the court whether it is possible for them to do so, even before the court makes an order.
Well, if you just joined us, we are discussing what would happen if myself and my partner or married partner bought a property together and we decide to go our separate ways. Would I be allowed or can I stay in that property? We're looking at that. We've looked at the interest you all have when we are acquiring the property to the interest of children that may be out of the relationship. If you have any further question, you can send your text to 0739920848. You can send a WhatsApp message, a voice note to the same number, 0739920848. Now the lines are active. You can call in, so to speak, and speak to Lawyer Eunice if you want to pose your own question. And 0208 493 7345 0208 493 7345. Or you can leave your comments and questions in the comment section down below. So, Leonis, with permission, shall we pick up some questions that we have on the platform first of all, and then wait for other people who may call us on the line or send their text to our text line. Good afternoon. I'm asking this question on behalf of my friend. The friend and her partner made an application together for citizenship at the same time on the 23rd of March 2025. The friend's partner has received an outcome on the 9th of June, but the friend still has not received anything up till now. So he's curious as to what has happened. And the next question is, what should he do? Laura.
Well, this is always one of those questions where I say you can make an application as a family, but the decision will never come at the same time. It's
Hmm.
what we call the home office delegating work to their caseworkers. So yes, you may have put in an application as a family, but different caseworkers will be working on that application, and different caseworkers have different workloads. So you cannot say that because one person's application decision has arrived, therefore yours has to come at the same time. Unfortunately, it does not work that way. And so usually they will send you an initial email, and the initial email will tell you that there is a period of 6 months in terms of them making a decision, or they will give you a time frame when the decision will be made. So just because one person's decision has arrived earlier than expected doesn't mean that yours should arrive at the same time. So you just have to bear with them in terms of the time scales they have given you. And if they do go over those time scales, they will email you again to let you know that they are going to need more documentations, or they are going to go over the time scales they originally gave you. And I really like that about citizenship applications. They always write back in terms of the time scales that they would be processing the application. So that's a good thing.
Right. Thank you very much, Laura. We'll pick up another one from the platform. Leave them in the comment section down below, either on Facebook or YouTube. This one says, good afternoon, Brakweku. I need clarification. When it comes to income threshold, do benefits like universal credit, can they be used or included in their earnings to meet the 29,000 threshold? If I want to bring my daughter to the UK, so the person wants to bring the daughter to the UK, income threshold 29,000. Wants to find out if the person is receiving universal credit, can they include that in the calculation of the 29,000 to meet the threshold? Uh, the person says they have leave to remain on a parent route.
Okay. So if they have leave to remain on the parent route, then that means that they themselves don't have settled status, and they have leave to remain. And so what would that would mean is that they are making an application for their daughter to come and join them here in the UK. Usually that 29,000 threshold is those who have made applications under the partner route, or those who are making applications for their spouses to join them, or their spouses and their children to join them in the UK. That is when that 29,000 threshold comes into question. If you are not applying on the partner route, or you are not applying for your partner or your wife or your husband and children to join you, that 29,000 does not hold. For children, what they look at is maintenance. And so you have a maintenance requirement under Appendix FM for a child joining a parent here in the UK. So that means that in most cases, if you are looking at maintenance, they are looking to see whether your income is sufficient in terms of the income support rate that they usually give to those who are on benefits in the UK. So the main reason why they are looking at maintenance is because they want to be able to see how much of the money is coming into the household and whether the child who is coming is going to be relying on government income or income from the parents directly. Yes, when it comes to maintenance, income coming to the household would include universal credit or any other employment income or savings. So, usually they will give you universal credit based on your circumstances and the number of children that you have. So, it does not include the child that you're going to bring. So, in order to show that you meet the maintenance requirement, there must be some extra income from somewhere, which shows that you will also be able to maintain that child when they are
when
coming.
they come in.
And usually, that's where the question lies. If the parent is able to um, show that they are doing some sort of part-time work and they are earning a certain amount in terms of the part-time work that they're doing, then that's fine because at least that helps the caseworker understand that this is their current situation. They are obviously on universal credit, but they are also working on a part-time basis, and they are looking to see that their child joins them here in the UK because their income that they receive should be enough to meet the child's need as according to the income support rates that are given to parents here in the UK who are looking after their children. So if they are able to show that the income that they are getting from maybe their employment is equal to that income support rate, then that should be fine.
Well, if you have any question or concern, Eunice is here. We still have some time on our hands. Bring that on, and we'll put that to her to help you have an answer. Good afternoon. Do I still need B1 in English if I have functional skills level 2 English, OET or IELT as English requirements for indefinite leave to remain?
So, Benjamin, when it comes to indefinite leave to remain applications, usually any application under the family route, because we have different types of applications. We have those under the private life and family route, and then we have those who are under the skilled worker or the work route. So I'm assuming that you are talking about indefinite leave to remain on the family and private life route. So if that is the application you are making, functional skills level 2 English will not be sufficient because under Appendix Core, they specifically state the English language test that has to be done in order for you to meet their English standard requirements. So you have those who may think that maybe because I've done some BTech or some um, MVQ courses, and so that should be enough. Unfortunately, they don't accept those. So you will still have to go and undertake their English speaking and listening test if you don't have an undergraduate degree or you don't have a master's degree or you don't have a PhD. Unfortunately, you will still have to go and undertake their English speaking and listening exam at a level A2 or B1. And usually for indefinite leave to remain, it's a level B1. So you would have to undertake the English test at a level B1.
Yes, we keep them coming through. Law Eunice is here. We're doing this courtesy BWF Solicitors, and it's a community and the law. Naomi Usu Sample, sorry. Good afternoon, lawyers. I want to find out how much I will pay for you to look out for the progress of my visa after administrative review success after 2 years.
Wow.
Um, how much do you want to pay? uh, once I think you may have contracted BWF solicitors already to look into this for you. So I would advise that, if possible, book another appointment, come speak, and they will have a solution for you. But as to how much you will pay, I will tell you. Like,
Yes, I mean, 2 years after administrative review has been successful, that's quite a long time because usually, once a decision for administrative review has been decided, it must be obviously up to the Home Office again to implement the decision that they've made. And so, if after 2 years you still haven't heard back from the Home Office, then obviously you need to make contact with them and get them to send you a new decision as soon as possible. So yes, do contact us again, and then we can take it from there.
yes, I think I got the answer spot on. Thank you very much, Laura Eunice. Naomi, please contact BWF Solicitors. If you lost the number, it's 0208 493 7340. MNS Ventures, please, lawyer, my friend got her indefinite leave to remain under the EUSS. She's waiting for a year, then she can naturalize. Can she travel within that 1 year, or would have to wait for the full 1 year before she can naturalize?
Okay, so usually if a person was married to a British citizen, then they wouldn't have to wait. They can immediately have their indefinite leave to remain and make their application for naturalization
Mhm.
soon after. Unfortunately, it is not the case. And so that means that when it comes to making an application for naturalization, you would have to show that you have your indefinite leave to remain, which means that you have no restrictions to your leave in the UK, and 12 months have passed since you were granted your indefinite leave to remain before you can go ahead and make that application. So, yes, they would have to wait for 12 months or 1 year before they can make the application for naturalization.
The next one we have here is, from our friend, Naomi Ususampo. I'll give you the number again: 0208. If you're watching, is at the bottom of the screen, but I'll repeat it: 0208 493 7340. 0208 493 7340. Remember, they work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. If you want to call, the lines are active: 0208 493 7345. Perpetual says, does someone who has a diploma in Ghana still need to do the IELTS before coming to the UK?
Well, when it comes to those who are coming on the skilled worker route, for instance, you would usually need to do an IELTS that tests your speaking, your listening, your reading, and your writing. And you need to do that at least at a level B1, depending on the job you are coming to undertake, or a higher level, maybe B2, depending on the work you are coming to undertake. If it's you coming as a family member, then you would need to undertake the IELTS for those who are coming as a spouse, or those who usually are coming under the partner route. They would definitely need to undertake that speaking and listening only. It doesn't include reading and writing. So speaking and listening only at a level A1 or higher. And so, yes, you still need to do an IELTS even if you have a diploma, because a diploma is not an undergraduate degree, it is not a master's degree, it is not a PhD. So, yes, you still have to undertake the IELTS.
Yes, thank you very much, Lawyer, for that. Remember, you get all this courtesy BWF Solicitors are trusted partners when it comes to the law. Leave your comments in the comment section down below or send them via text to us 0739920848. If you want to speak to Lawyer Eunice now, 0208 My wife is an EU national. She's been refused on a 5 year continuity. I'm due for settlement in September. Can I divorce and retain my rights, or is there anything else I can do?
Usually, for an EU national to be refused on the EU settlement scheme, it's either that they are not able to show that they've resided in the UK for a continuous period of 5 years, or that they do not meet some of the um, requirements under Part 9. So, Part 9 of the immigration rules is to do with those who may have criminal convictions or exclusion orders, or may have presented false information. I mean, he doesn't state the reason why his wife was refused, but in terms of making an application, he says, can I divorce and retain my rights, or what can I do? If you are yet to make the application, as long as you can show that you've retained your right here in the UK. So, obviously, if it's on the basis that she was not able to produce enough documentations to show that she's resided in the UK for the 5 years continuous period, then of course it would make sense for you to make the application on a retained right basis. Because if, for instance, she wasn't able to show that for the last 3 years she has lived in the UK, then that means that you have not been together for the last 3 years. And therefore, you would have to show that you were married for at least 3 years, you have lived together with your wife for at least 1 year, and that she was here at the time you were about to start divorce proceedings, and you have continued to remain in the UK even after divorce proceedings had ended. And so you will need to make sure that you can show that you have actually retained your right before going ahead with such an application.
Thank you very much, Lawyer. The next question here is from our friend Ventures again. Um, Maybe to give a context to that, we have to go to the previous question. It says, my friend got her indefinite leave to remain under EU as she's waiting for 1 year, then she can naturalize. Can she travel within the 1 year or have to wait the full 1 year before he can naturalize? And then the follow up question says that, I mean, if she travels within the 12 months, will it affect the naturalization?
Oh, okay. So if you have indefinite leave to remain, you can travel anywhere. I think obviously when you make an application for naturalization, it is to see if you can obtain British citizenship. So that does not affect your indefinite leave to remain. I think once you've gotten a decision and you've booked a date for the naturalization ceremony with your local authority or your local council, usually they say that once you've obtained your certificate, you cannot travel until you've applied for your passport. So I think the general rule is once you've received your certificate, you can't travel until you've obtained your passport. So you can still travel whilst the application is still with the Home Office. Yes.
Okay, right. Thank you, Eminence Ventures, for your question. Thank you, Laura Eunice, for the comprehensive and good answer over there. Let's see, we have Collins of for each. How long is British passport, or how long does it take for a person born as a British to have their passport? I did my child's passport application in April 2025 and still have not heard anything from them. I think that's what Collins wants to put across there.
Okay, so usually I don't think anybody is British born until their parents is saying that they themselves are settled or British. So if, for instance, he's saying that he's settled or British and he's made a passport application for his child, usually they're very good in terms of giving time scales. As soon as you make the passport application, they will respond to let you know whether it would take 3 weeks, 6 weeks, how many number of weeks it will take them when you make the application. And usually I know that some of us may not be very well versed with the internet, so we would use the paper application. Usually, with the paper application, they will still write to acknowledge that they have received your application. If they do need anything, they will write to you. If they don't need anything, usually within 3 weeks, hopefully you should receive your passport from them, unless obviously it's a busy time and because of the amount of workload they have, they might tell you track your application online. It might take a further 6 weeks, or it might take a further 2 weeks than expected. So it's good to make the application online so that you can track how long it will take them to bring the passport. Yeah.
If you have any question, just send us to us 7399208468 or call 0208493745, or you can put them in the comment section down below like Smith Mercy has done. Lawyer, she says that a few weeks ago, the advice to people was to apply for retained rights if the divorce or sponsor had died, to ensure people don't go into trouble entering the country after holidays and the like. What has changed now for the new advice that retained right is not application, but a legal procedure to when applying for indefinite leave? Thank you. My friend applied for retained rights after 4 years of marriage and was granted another pre-settled, which is fine with her. She was due for indefinite in 3 months' time. So I think there's this confusion as to a new thing that's been said about retaining your rights, and also when people's partners have left or died, so to speak.
I'm thinking it has to do with the announcements we have been making regarding the government saying that instead of um, you showing absence um, of more than 30 months, they are willing to look at absences of 30 months or less.
Mm.
And that is something they are willing to consider. It's not an obligation on them to consider that in terms of your settlement application. That has nothing to do with your retention of rights. I think that a lot of people are confused about when they can make their application for settlement. Please, if you are a family member of an EU national or you have retained your rights, the time period is always 5 years qualifying period. So if you are saying that you became a family member of an EU national in the year 2020, you applied for pre-settled status, you can only apply for settlement after 5 years. And so any point in time after the 5 year period, you can make an application for settlement or settled status. If you are saying that you have retained your rights because maybe you were divorced from the person or the person died, as Smith Mercy is putting it, if the person passed away and you were granted retention of rights, and most of the time if you apply for retention of rights you will be given another 5 years. That does not mean that you will have to wait till the end of those 5 years to apply for settlement. It only means that you will have to show you have resided in the UK for a 5 year continuous period from the time you became a family member of an EU national. And if you can show the continuity in terms of your evidence, and you can show that yes, you have lived here continuously for a qualifying period of 5 years, then you can make the application for settlement. So if her 5 years is going to be up in 3 months' time, Yes, within that 3 months, or after the 3 month period, she can put in her application for settlement to show that she's resided here for that 5 year qualifying period. And yes, she made an application for retention of right because the EU national has passed away, but she still meets the requirements and therefore she's making an application for settlement. And if she has not been absent from the UK for at least a period of 30 months, then she's looking good to go in terms of being granted her settled status in the UK.
For the sake of time, I will take just one more, and then I'll come back to my scenario I gave you and test your knowledge on that. Austin. Lawyer Austin is saying that if you are under pre-settled and you have gone for your children from abroad, the children too have been granted 5 years. If I'm granted indefinite leave to remain, can I apply for the children or I should wait for them to spend their 5 years?
Well, it depends on how old the children are.
Mm.
So, any child who is 21 or above, because they are seen to be dependents, you will have to wait for them to run their 5 years before you can apply for indefinite leave to remain. If the children are under 21 years, then usually you'll be making the application for them to receive the same settled status as their parents and the EU national here in the UK. And most times, if the EU national has indefinite leave to remain and the parent also has indefinite leave to remain, it's likely that the child will also be granted indefinite leave to remain based on the government's policy, or should I say concession, which was in place. So it's not directly under Appendix EU, but it's a concession that the government put in place.
Well, I'm going to my scenario and I'm going to ask the question about Fifi and Araba. So just pay particular attention to the story and give me what the likely outcome of the appeal will be. Araba and Fifi married under Ghanaian customary marriage law on the 1st of June 2022. On the 30th of December 2024, they registered their marriage under Section 2 of the Ghanaian customary marriage and divorce registration laws of 1985. They were subsequently issued with a certificate of marriage, which indicated the date and the registration, also the date of the marriage and the date for the registration, both of them. Under Ghanaian customary marriage laws, one can register a marriage at any time in the future after the marriage has been contracted. So Araba, with this knowledge in the background and based on that, applied for a visa in May 2025 to join Fifi in the UK. Araba's application was refused in June 2025. The caseworker said that as the marriage was contracted on the 1st of June 2022, it should have been registered on the same date. Therefore, according to the caseworker's argument, the marriage was not valid and Araba could not be the spouse of Fifi. Araba has appealed against the refusal decision. Then I'm asking you, what would be the likely outcome of the appeal? An appeal will be allowed because Araba can prove that both she and Fifi attended their marriage in Ghana. Would it succeed? Or would it be allowed because Araba can prove that their marriage to Fifi was valid in Ghana? Or would it be allowed because Ghana is an independent nation? Think about these. Take a deep breath. Drop your answers either via text or online at BWF Solicitors at BWTV UK, both on Facebook and YouTube. And when I come back, I will be looking at them. Who is going to get it right? I don't know. When you have given me the answers, Lawyer Eunice will help us to get it right, and then we can empower ourselves with that. It's the community and the law. I'll be right back. Welcome back. And let's see what you gave me. I asked you to think through the scenario and give me what the likely outcome of the appeal would be. Setorusu says the appeal will be allowed because Araba can prove that both she and her husband Fifi attended the marriage in Ghana. Kwajoedu thinks it's number two. An appeal will be allowed because Araba can prove that their marriage to Fifi is valid in Ghana. Mustafa, number two. Thank you, Mustafa. Regina, number one. Thank you, Reggie. The next one here says it's number one, Echai Hinkra. Thank you for that. Um, let's see what lawyer will tell us. Margaret Asante says it's number one. Appeal will be allowed because Araba can prove that both she and Fifi attended their marriage in Ghana. Benizo Poku thinks it's number two. The appeal will be allowed because Araba can prove that their marriage to Fifi is valid in Ghana. Peggy Mensah says it's number two. Yes, Peggy, thank you as well. Um, Matilda Asari, number two. An appeal will be allowed because Araba can prove that their marriage to Fifi is valid in Ghana. Millicent Ado thinks number two as well. Thank you, Millie. The next one, Joe Fari says it's number one. An appeal will be allowed because Araba can prove that both she and Fifi attended their marriage in Ghana. Nana Japan thinks it's number two, valid in Ghana, so it should be allowed. Josephine Boachi thinks is number two, number one, sorry, Joe, an appeal will be allowed because they can prove that. Well, Richmond Yadom also thinks it's number one. Richie, well, let's see what lawyer will tell us later on. Mark Oduro, Mark thinks it's number two. It will be allowed because it's valid in Ghana. Ekuya Pokuya thinks it's number two as well. Thank you, Ekuya. And I think that's about it. So let's see. Um, if it was in an auditorium and all that, then it would have been the trumpet. Pam, pam. Rebecca Marco, you think it's number two. With that, I'll go to Laura Eunice. Laura Eunice, help us, please.
Yes, I think obviously some people may be confused as to um maybe what a customary marriage is. And so I would like to explain from that point of view. So when we say Ghanaian customary marriage, we are usually talking about a traditional marriage ceremony. So most people will call it engagement. I think traditionally it is known as a traditional marriage because both families come together. The customary rites are performed where both parties have planned the day of the ceremony. They have done the knocking. They have agreed the items that should be bought to perform the marriage rites. And usually that will include a dowry, which will be given, drinks, suitcases of cloths, very expensive quality cloths. And if they are Christian, they would include a Bible together with the ring. And so that is what is termed as a Ghanaian customary marriage. Whereas a marriage by ordinance is where the two people go to the registry, they stand before a registrar, pronounce themselves husband and wife, and then they sign the marriage certificate. In terms of a Ghanaian customary marriage, you don't do that. Both families will perform the marriage rites, and then it is up to you to decide whether you would register it or not. So there is no obligation on the families to register the marriage. So it is only under the PNDC law of Ghana that you would realize that if the couple decide to register the marriage, then they can do so at their local municipal assembly or metropolitan assembly. So if they choose to register their traditional marriage, the one where both families have sat down and performed the customary rites, then they can do so at a later date. So it may be that they got married 10 years ago, but they are now registering the marriage because they want to have some form of evidence to show that they are indeed a married couple. And if that is the case, they will go to their local metropolitan assembly to go and have their marriage registered. And usually it will be a Ghanaian customary marriage certificate together with a statutory declaration, which will inform um, whoever is looking at it, the parties that were involved, those that stood in for the husband and the wife, whether the rights were performed to a standard that needs to be met, and whether the parties have also consummated and agreed for all of this to be done. So the statutory declaration will go together with the customary marriage certificate, and if it's to be used in the UK, they will have an attestation from the Foreign Affairs, an attestation from the Judicial Services, and then one from the local municipal assembly or the Metropolitan Assembly. And then once it arrives in the UK, they will also need an attestation from the Ghana High Commission to confirm that all the documentations are genuine. Okay, so once you have all of this in place, you should know where you stand. So when we look at the answers, it says an appeal will be allowed because Araba can prove that both she and Fifi attended their marriage in Ghana. Not necessarily. The fact that they both attended maybe their customary marriage 10 years ago does not necessarily mean that the court should allow their appeal. So let's look at option two. It says an appeal will be allowed because Araba can prove that her marriage to Fifi is valid in Ghana law. And so, according to the PNDC law, if a customary marriage is to be registered, which there is no obligation for it to be registered, the couple can go ahead and do so at a later date. It does not have to be at the time of the marriage. And so, if it is seen to be valid in the country in which it was performed, then it will be accepted within the UK, because the Family Act of 1996 will ensure that the marriage was conducted within the legal framework of the country where it was performed. And if they are able to show that, yes, um, the marriage was done within the validity of the laws in Ghana, then it will be accepted here in the UK. So option two is our answer.
Option two is our answer. Yes, the appeal will be allowed because Araba and Fifi married under Ghanaian marriage laws and is valid in Ghana. So, as it is valid in Ghana, it is accepted in the UK. Therefore, the court will determine that the caseworker's reason for refusing Araba's application based on the late registration of her marriage cannot be a valid one. So thank you very much, Lawyer. Thank you for those who selected option number two. Those who got it wrong, yes, we've given you the reason for the answer. But then with that, we go to Lawyer Eunice again, so to speak, for a brief summary of what we discussed today before we draw the curtains down. Lawyer.
Yes, so today our topic was to do with, can I remain in the property that obviously me and my cohabitee partner purchased together. Yes, if you can show that you made some form of financial contribution towards the deposit and the mortgage, or towards the down payment of the property, you may be able to remain in that property, depending on whether you are still capable of making such financial contributions if there is still a mortgage. Yes, also when it comes to the law, if you're not a married couple, then the only way you can try and get the court to make an order on your behalf is for you to show that you both own the property on trust. And so, if both parties have their names on the title deeds, whether as joint tenants or tenants in common, then the court will look at that as their first point of considering whether to give the property to one party or the other, they would make that a point of consideration, and they will also consider if there are children within the household, and the fact that the children's needs need to be made paramount. Once the interest of both parties have been considered, and then the children's interests have also been considered, the court may now make a decision to go ahead to allow one party to remain in the property based on either their financial contributions or the fact that the children are young and therefore they would need to remain in the household until they are old enough to leave. And such would demand that the parties hold on to taking out equity until when the children are old enough to leave the property. When it comes to BWF solicitors, we do not only deal with immigration law, we deal with other aspects of law, including family law as well. And so, if you would want to seek further advice, do not hesitate to contact us from Monday to Fridays on the contact details you can see on the screen, and our office details will be put on the screen as well.
And obviously, they do not only help you understand that, they empower you with legal education. That's what we do on the program, the community and the law, as we've done today. Today is the last Saturday of the month of July 2025. I want to say thank you to Lawyer Eunice for your time. You'd realize that she's a bit under the weather, but she's giving us 2 precious hours of her day. Thank you, and we appreciate your effort. To BWF Solicitors, from Uncle Ben to the very last person, that's me, we want to say thank you so very much for your time, your effort, the preparation to this program, the research, and the production. To Sheila and Krempano Dodu, thank you so very much for helping with the production. Not to forget my able producer, Professor Ade, for his effort and everything he does to make sure that we come your way. My name is Oreku Frimpon. I want to say thank you for your time. We'll be moving into a new month next week, and we'll come again with another edition of the community and the law. Until then, stay cool, stay good, and God bless you.